Defamation. Defamation is a tort, but it can get a little complicated. So it's going to get its very own little video. Here's the definition, and there's two types of defamation, libel and slander, and there it is. And there's your test. So if you're copying and pasting this or using it in a homework or on an exam, it is the test that you will copy and paste. Now, these can be a little tricky. There was a defamatory statement. If I say, you're a stupid cow, is that a defamatory statement? Well, let's think about that. Is it false? Well, it's false in a literal sense. If I'm saying that to another human, another person, they are certainly not a cow, right? But is it false in a broader sense? Is stupid cow a phrase that we recognize as indicating something? Do you see what I'm saying? So a defamatory statement can mean the literal word. If I call you an idiot, that literal word. Or it can refer to how a word or phrase is understood in context. It was communicated means simply that it was spoken or written, and there has to be an actual injury caused by the statement. So it's not enough for me to say, you are a stupid cow. If I say that and the two of us are out in the hallway and no one else hears, that might be irritating, but it might not cause you an injury. However, if I said it in front of a small group that you were participating in, and then as a result of that, the group refused to work with you, and as a result of that, you got a poor grade, well, that's an injury, if you see the distinction. Here are the defenses to defamation. The first one is opinion. You are absolutely allowed to have an opinion, and you're absolutely allowed to express it, even if your opinion is negative. Opinion cannot be false because it is opinion, even if it can cause injury. Don't get too hyped about that, because what is an opinion and what is a defamatory statement can get pretty fuzzy. But we know that satire is considered opinion. And this satire piece and this public person piece has combined together in a Supreme Court case that's very important to understand defamation. And in this case, it was Hustler Magazine versus Jerry Falwell. Excuse me, I had that backwards. The plaintiff was Jerry Falwell and the defendant was Hustler Magazine. And what happened in this case is that Hustler Magazine has a piece every month in which they have a pretend article called My First Time. And it's written as if it were a interview. And in this particular version, Hustler Magazine purported that Jerry Falwell had said that his first time was in an outhouse with his mother and that both of them were drunk. Now, that's not true, so we come back to the test. That is defamatory, right? I mean, I would be offended if someone said that about me and published it in a national magazine. And it is false. Jerry Falwell never consented to an interview with Hustler. They just made it up. It was communicated. It was published in their magazine, and it caused actual injury. Jerry Falwell claimed, and I think rightfully so, that it was injurious to his reputation and that caused him pain and suffering. However, it was found to be satire. That is to say, that what the court said is no one reading that article thinks that Jerry Falwell actually said that. It was a joke. It was a satire as a political tool meant to highlight a broader issue about Jerry Falwell. And in this example, the issue was that he was a hypocrite. And in order to come to that decision, they made a distinction between private people, limited purpose public people, and public people. And there you are with number 2 in the defenses. So what this means is, if you are a private person So one of the students in the class, then that would be and Hustler Magazine published that article about you. That would be defamation, and they could be sued. However, if you are a public person, and a public person is someone who has willingly injected themselves into the public view. And if you are a public person, then the only way that you can win a defamation is if the defamatory statement was made with actual malice. So you just have to put with actual malice on the end of that first line. And it says it right here. That's almost impossible to prove. So public people, that would be President Obama or President Bush or Jerry Falwell or Madonna or public people, cannot win a defamation suit in the United States because of this test. That's only true in the U.S. and any other country, including in Great Britain. Defamation makes no distinction with who the victim is. A limited purpose public person is a very peculiar thing, and it's only, again, it only exists in the United States. That is someone who has become a public figure for a narrow purpose. So if you are a miner and you're trapped in a mine, then you and your family become limited purpose public people. Because of this event, the press and the public want to know, and then things that are involved in that mining accident become public. So a good example of that is when the Columbine shootings happened, the chief of police became a limited purpose public person. So it became appropriate to talk about, does he have a drinking habit? Does he is he thought of as a good chief of police? All those things that were around that case. Excuse me. But at the same time, he was going through a divorce, and the divorce was still private because it didn't have anything to do with this, with the Columbine shooting. That is, as you see, that's a very tricky standard. So if it has to do, if the defamation has to do with your role in that public part of your limited purpose, then you can't sue. And if it has to do with your private part, then you can. Good luck. That's a tough distinction. That's a distinction that a lot of lawsuits are brought about, but it's kind of fun to think of. The third defense is privilege, and there's two kinds of privilege. Absolute is in a courtroom or a legislative hearing. So if I'm in court or if I'm testifying before Congress and I've taken an oath, I can say whatever you ask me, and I cannot be sued for defamation. So if I'm in a courtroom and they say, tell me what you think of Muhammad, and I say, I think he's a stupid cow, I cannot be sued for defamation even if he is a private person. It's an absolute privilege. I'm absolutely protected in that space. A conditional privilege, or qualified privilege, it's sometimes called, is if there's a reasonable and legitimate need for this communication. And if the communication is limited to only what we need to hear, then it's protected. That makes me sigh because that's a tricky standard. So if, for example, at work there's an investigation and Human Resources comes and sits down in my office and says, we're investigating Muhammad, tell me what you think of him. And I say, well, I think he's a stupid cow. If they needed to hear that in order to, and as part of their investigation, if that was central to that, then it's privilege and I'm protected. If it wasn't, if I just said it because I'm a jerk, then it's not protected, and I don't enjoy any protections around that. And that's it for defamation. Thanks.